Welcome to Gitterman, and Feld. You currently have an upcoming appointment set with a forensic evaluator. This could be a panel qualified medical examiner, an agreed medical examiner, or an IME called an independent medical examiner. So if you like alphabet soups, we've got PQME, AME, and IME. Regardless of the title of the evaluation, that physician is not there to treat you. They're not there to help you with your case. They're supposedly an objective, neutral evaluator who's going to listen to what you have to say about your condition, do a physical examination, review your medical records, and provide what we call a medical legal report that will discuss your claim, including whether or not you have work-related injuries, what your current disability status is, whether you have reached permanent and stationary status, which I like to call you're as good as you're going to get. It doesn't mean that you don't get more treatment. It just means that the doctor's run his course in terms of what he thinks can be done to improve your condition. So if you are permanent and stationary, the doctor is going to do an assessment of your level of residual impairment. And he will also make an assessment of what we call apportionment, which he's going to allocate the cause of that impairment to work-related issues and to non-work-related issues. The doctor will describe your anticipated future medical care needs. And finally, the doctor will render an opinion about whether or not he believes that you can return back to work performing your usual duties with or without accommodations. The important things to remember in a forensic evaluation is that don't be an advocate. Don't exaggerate. Don't talk in hyperbole. None of that helps you. And most of the time, it doesn't really work in your favor because the doctor is simply perceiving that you're trying to win your case in the examination. That rarely happens. What the doctor is going to be doing, though, is looking for inconsistent presentations. So if you are being examined by the doctor for a neck injury, and you tell the doctor that you're not able to turn your head to the left or to the right because of the restrictions in your range of motion, the doctor will listen to that. But the doctor will listen to that while he's sitting right next to you at a different part of the examination, and you've turned your head to look at him, even though you told him you're not able to turn your head to the right. So it's important to be consistent with what you tell the doctor as well as your actions. The doctor will watch you as you're walking into the office and watch you as you're walking out of the office. So if you tell the doctor you walk with a limp, but when you walk into his office, you're not walking with a limp, and when you walk away from his office, you're not walking with a limp, the doctor is going to question your credibility as a patient. And that's the one thing that you can lose when you go into an exam is your credibility. That's why exaggerating and talking in hyperbole just doesn't help. It's that whole sense of credibility. Can the doctor trust what you're telling them is accurate? And they'll compare what you tell them with what your medical records say as well. Nobody can remember everything that's within their medical records, at least not that I'm aware of. But you do the best you can. The key is not to try and hide information because ultimately at the end of the day, the doctor is going to have that information. If you've been hurt in the past and you remember that, you make sure you tell the doctor that. If there are activities that you've tried to do but haven't been very successful at, like, you tried to mow your lawn and as a result you ended up in pain, make sure to let the doctor know. I tried to mow my lawn and I ended up in pain and I was on my back for 2 days. It's always important to inform the doctor of the problems that you're having. And that means all the problems. There is one certainty in the workers' compensation system. If it's not on a medical report, it doesn't exist. You need to make sure that you tell the doctor all of the conditions that you believe are related to your work injury. Be straight, be direct, be forthright, show up on time, participate in the process. If the doctor has not examined you within an hour of the date of your appointment, you are allowed to leave. You don't have to wait for the doctor to see you. That's a judgment call on your part. If you choose to leave, that's only going to result in further delay in your case. So you might want to check in with the doctor's office to find out just how much longer it's going to be. The doctor has to treat you respectfully. They can't be rude. They can't harass you. They should not be making judgments about your claim or even really speaking to you at all about their findings or their opinions regarding your claim. If they are doing so, it's only to keep you mollified rather than to express what they really believe. I can't tell you how many clients I have who've come back to me after an examination telling me all these great things the doctor said, and yet the report says something different. And that's because maybe the doctor just doesn't want to get involved in an argument with you. So it's really counterproductive to even have that conversation in the first place. Let the doctor do their job, take a history from you. That's just question and answers. Do the physical examination. Let him read the reports, obtain diagnostic tests if he needs to, and then issue his report. Once the report issues, we'll contact you to go over the information that's contained in the report to make sure that it accurately reflects what happened at the examination. A couple of things to keep in mind: track how long the doctor actually spends with you face to face. Just basically, I saw the doctor at 2:11 and he stopped seeing me at 2:23. That can be very helpful to the people who are handling your claim. It also helps us to ascertain whether the doctor is being accurate as it relates to what he put in the report, or she for that matter. So participate, don't resist, don't make up symptoms, don't mimic or feign severity when it's not there. It doesn't help. Doctors have tests that they can do, which will, if an individual is not being forthright or straightforward, it actually will reveal that they may be fabricating or manufacturing a complaint. An example would be a light touch or a compression test, where a patient complains about pain when that type of test should not elicit pain. So it's just better to stay even with what happens within the exam. And if you do have questions, make sure to contact us and we'll be happy to talk with you about them. Thank you again for retaining Gitterman and Gitterman and Feld, and we hope you have success with your forensic evaluation.
All right, I actually do have some questions for this one.
Okay.
So what if I forget to mention a symptom or an incident where I had a symptom or had some trouble doing something and I meant to, but I just forgot to do it? Is there any way to add that to the report afterwards?
Reports can always be amended through your testimony, but the better way to protect yourself from that, frankly, is to write down your list of symptoms before you go in to see the doctor. Then you don't have to remember them. You can just read them from a list. Make a list of the medications that you're taking, the dosage, the name of the medication, how many times a day you take the medication. All these things can help you so you don't have to be put on the spot about remembering things. If you have a list of the healthcare providers you've seen or the treatment that you've been provided, you can make a list of that as well. And you can refer to that list in the examination if the doctor asks you. In all likelihood, if you offer the list to the doctor, he or she will refuse to accept that list. But you can still use that list to provide that information to the doctor. But that's a really good question.
Awesome. Thank you for answering my question. I have one more.
Sure.
So what if I disagree with the findings in the report and don't feel they're reflective of my injury? Is there any way to get a second examination?
Wow, that's a really good question. Ordinarily, if we disagree with the doctor's findings, we'll rely on the information you give us and take that doctor's deposition or send the doctor a letter. Unfortunately, within the workers' compensation system, the forensic evaluator who performs the exam is usually the ones we have to depend on. Sometimes there are medical legal reasons why we're able to get away from that doctor, and we certainly would make every effort to do so, but there's no guarantee that will happen. It really depends upon the reasons why you disagree with the doctor and whether we can show that the doctor had an incorrect set of facts or was relying on the wrong medical legal theory when offering the opinion.
Okay, those are my only questions. Thank you for answering them.
You're welcome.